Welcome back to The Verdict. I'm your host, Tammie Smeltz. Today, we're reuniting with one of our go-to experts in the med-mal defense space, Jonathan Erman, for an insightful conversation you won't want to miss. Throughout the podcast, you might notice us speaking about scleral icterus. This is actually a misnomer. The correct term is conjunctival icterus. Thank you for listening. Hi, John. Thanks for coming back on The Verdict. We always enjoy having you on as a guest.
Thank you for having me, Tammie.
And I guess I'll still say Happy New Year because it's still January, early January. So Happy New Year and Happy New Year to all our listeners as well. Today, we're going to talk about an unfortunate case involving an infant plaintiff. And as you listen to John's story, you'll see why sometimes it's better to just resolve a case early. John, can you tell us a little bit about this case? What are the facts surrounding this case?
Okay, so the facts of this case are interesting. This is the first time I ever handled a case such as the one we're going to be discussing today. In March of 2019, the infant plaintiff was born at a local hospital in New York City. The delivery went well. It was considered a well baby, full term, appropriate weight. And after 3 days, the child was sent home with mom in very good condition. The mother was told and promptly returned to her pediatricians for purposes of well visits. Many people who have had babies before are told to be looking out for what's called jaundice, yellowing of the eyes, or your sclera. The child was being followed by a pediatrician who was board certified, as well as a family practitioner, both of whom worked in the same practice. And as time went on, during these well visits, the mother started to notice something that just seemed odd to her. Mothers call it mother's intuition. In this case, the mother's intuition ultimately became correct. What happened? During these well visits, the mother would reportedly tell the physician's assistant, as well as the two physicians, that she had concerns, that to her, it seemed as if her child was exhibiting signs and symptoms compatible with jaundice. Now, jaundice is the yellowing of the skin, but with babies, it's mostly prevalent in their eyes. It's caused by a buildup of your bilirubin in your blood. And the concern when someone exhibits jaundice is the concern that in this case, the infant's liver was not processing the red blood cells correctly. Now, pediatricians are aware, and it's known, that newborns, especially premature infants, can develop jaundice. In fact, pediatricians will say that the majority of time when an infant presents for a well visit, the jaundice could be as a result of breastfeeding or breast milk jaundice. You'll learn, and I'll explain to you, that when the case was first called in, what do I mean by called in? I mean that the two physicians in this case, they likely received a request for medical records. The medical records were forwarded to an attorney, and ultimately a summons and complaint was served on these two physicians. Now, my job as a defense attorney, in collaboration with the malpractice insurer in this situation, when we learned of this lawsuit, what we did was what's called a prompt assessment. We met with our clients, we obtained the medical records, and after reviewing the medical records, we decided we need to get an expert, or in this case, a couple of experts involved. What we came to learn, and my clients were very forthcoming. Again, they were both, one was a board certified pediatrician, the other board certified in family practice. What ultimately happened here was approximately 18 weeks after the child was born, at the urging of the mother, ultimately a bilirubin test was performed. This is not a very difficult test. It's essentially blood work that was drawn on the infant, and the bilirubin came back extremely elevated. The child was born in March. Late July, the bilirubin was drawn. The blood work revealed extremely elevated bilirubin level, 21. Normal is anything below 1.0. So we're dealing with a child who at this point had, and ultimately was diagnosed following a biopsy, biliary atresia. Biliary atresia is pretty rare. It occurs in newborn infants. It's essentially where the common duct between the liver and the small intestine is blocked or is absent. It affects approximately 1 in 20,000 infants. And it's unfortunately the most common reason for an infant to require a full liver transplant. So that's essentially what the case is about. I'll break it down even more basic. We have a mom complaining of her baby exhibiting signs of jaundice. The two physicians allegedly failed to order a blood test to determine the bilirubin, and subsequently the child was noted to have a condition called biliary atresia, which essentially can result in and does result in ultimately liver failure. Now, this condition can be treated depending on when the diagnosis is initially made. According to experts, according to the medical literature, the optimal time to diagnose this condition is within the first 100 days of the newborn's life. Unfortunately, when this infant was diagnosed with this condition, that window had closed. As you will learn during the course of this discussion, we were stuck with a situation in which both of my clients conceded to me that they dropped the ball, meaning they should have ordered a bilirubin test as soon as mom started to make complaints that there was a concern that the child was exhibiting jaundice. What made this case even more difficult to initially defend the quote liability aspect of it, meaning did my client depart from good and accepted medical care in failing to order the proper blood work, was the fact that mom and dad took pictures of the infant, and by looking at these pictures, any layperson would say that the eyes of the infant plaintiff looked yellow.
Wow, John, thanks for that. So once the diagnosis of biliary atresia was made, what was the treatment this poor infant had to undergo?
By August of 2019, once the total bilirubin came back extremely elevated at 21, the infant was properly transferred to a higher tertiary care center in New York City, where based on further testing, the decision was made that a surgical procedure by the name of a KASAI, K-A-S-A-I procedure, where surgeons remove the damaged bile ducts and connect the small intestine to the liver to create a new path for the bile to move or to help restore the liver function. It could not be done. As such, the infant, again, based on an extremely elevated bilirubin level, the concern for total liver failure was placed at the top of the transplant list, and ultimately at the end of August of 2019, received a total liver transplant. Now, that will ultimately be the crux of this case. When plaintiff's attorneys brought this case, the argument that they made were that my clients departed from good and accepted medical care in failing to note the jaundice, conduct a further investigation as to the cause of the jaundice, that this delay in failing to diagnose what was ultimately diagnosed, in this case, biliary atresia, the infant plaintiff lost the opportunity to undergo the Kasai procedure. Instead, the child had to undergo a complete liver transplant. That was what the plaintiff's attorneys were going to argue. Now, this is where this case is different than the majority of my lawsuits. The case was begun in early of 2020. For reference, for those who are listening, just before the pandemic. The case was brought. We meet with our clients. We do a prompt assessment of having a meeting with our clients, going over the medical records. We start to obtain additional medical records because we want to know the current condition of the child when the case is brought. My first initial meetings with my clients were difficult in the sense that both of my clients, understanding what ultimately occurred here, conceded to me. They said, "John, we dropped the ball. We failed to diagnose the elevated bilirubin, and from reading the summons complaint or the allegations that were being brought against them, they essentially conceded to me that what the plaintiff's attorneys were arguing rung true." Now, that doesn't just mean, okay, let's close the doors, let's end it immediately. No, what my job and your insurance company's job at this point is to do, is to say, okay, we know that our clients are conceding that they departed from good and accepted medical care. However, the next question you have to ask yourself is, well, what difference did their departure really make in the ultimate outcome for this infant? It's a difficult concept to understand, but it's called causation. Meaning, although my clients may have departed from good and accepted medical care in failing to order a blood test based on the mother's complaints of jaundice, what difference did it make in the ultimate outcome that occurred in this situation? It's at this point that we decided, let's get all of our medical records that we can, and let's start getting experts. People in the field of transplants, liver transplants, pediatric surgeons. In this situation, we retained two experts. We retained an expert who highly regarded, well-written, curriculum vitae is incredible. We're talking 100-page curriculum vitae or resume to those who are laymen, who reviewed the matter. We also decided, let's also get an expert, a surgeon who does transplants, to comment on this case and not focus on what my pediatricians and family practitioner did, meaning let's putting aside the liability issue, let's talk about the causation issue. And it was interesting. And Tammie, I remember like it was yesterday. Granted, it was back in 2020, and here we are speaking in 2026, early 2026. But I'll never forget. I received a phone call from one of the experts. In this case, it was the pediatric surgeon out of Philadelphia, Children's Hospital of Philadelphia. And he said, "John, I'm reviewing this case, and I have to tell you, the plaintiff's really lucky." Of course, I was driving and I almost crashed my car, but I actually said, how can you say that this infant's lucky? He said, well, I hate to say it in this way, but your client's failure to note the elevated bilirubin and liver failure means that the infant plaintiff jumps the list. I said, what do you mean, doctor? What do you mean by jumping the list? Well, because his liver failure was progressing so quickly, he got to jump the list, meaning he will be able to get a full liver transplant quicker than most. And I still to this day, 100 cases later, still remember saying to him, but what about the claim or the argument being raised by plaintiff's attorney that the Kasai procedure, had our clients diagnosed it earlier, would have been the end all be all, meaning the child would not have required a full liver transplant. And this pediatric surgeon, world renowned, said to me, it's a good argument, but we as surgeons, and the literature will show it to you, John, and I'm going to forward it to you after this phone call, indicates that the Kasai procedure is a stopgap. It's temporary. It's palliative in nature, meaning we as surgeons know that, yes, had your clients diagnosed the elevated bilirubin and jaundice in a timely manner, this infant would likely have underwent the Kasai surgical procedure. But John, and this is what's going to help you and your clients at some point, we also know that this temporary stopgap in the form of a Kasai procedure is just that. The infant, at some point, most likely by age 5, 6, or 7 years of age, would then be required to go back onto a liver transplant list and patiently wait for purposes of having what was ultimately done here within 3 months of his life in the form of having a complete liver transplant.
And I think from a medical standpoint, that sounds, accurate and correct, but I bet that would be a hard sell to the jury, right? If this case ever went to a jury.
Right. So I know we've talked about this before, Tammie. A lot of different ingredients go into these types of cases. And I use the word ingredients for those who cook, right? So basically, we have a perfect family, cases vented in Supreme Court, Kings County, i.e. Brooklyn. Would a jury understand that my client's departures in failing to order the proper blood test actually resulted in a better result for this infant? Probably not. They would probably look upon me or any other defense attorney as just playing, quote, games, right? That we're trying to throw something over their eyes and we're trying to just minimize the damages in this case. A decision was made with my client's permission to say, you know what? We departed. Let's see what we can do about resolving this case. Now, Tammie, I know we've had this discussion before. It happens to me all the time. I can go out with another couple for dinner, a couple we've never met before. And the first things that always come up when you meet new people are, what do you do for a living? Well, when I say what I do for a living, there are so many times where someone will say, well, John, I see all the ads on television or while I'm driving my car on the radio about lawyers and medical malpractice. Tell me, are most of these cases frivolous? My answer always is, not all of them. How many of these cases, John, go to trial? I always say it really depends on the case, the venue, meaning where the case is located, my client's position, et cetera, et cetera. And then the next question ultimately is, well, how many of these cases ultimately settle? And I say, it depends on the case once again, but some of them do settle. This was a case that everyone felt needed to be settled. And depending, I know that defense attorneys get this rap or reputation of trying to prolong cases that probably should settle. In this situation, that did not occur. Even before depositions, that's the capability of the plaintiff's attorney to question the doctors about the care and treatment that was rendered. Even before depositions, we made a conscious decision to try to resolve this case. We felt that with our experts on board, an argument could be made at the process called mediation, I'll discuss it in a second, that damages were somewhat limited in this case. Yes, my clients may have departed from good and accepted medical care in failing to perform a blood test, failed to diagnose in a timely manner the biliary atresia. But as my experts both indicated to me, the child was a candidate and jumped the list for a liver transplant. Not a stopgap treatment, but a definitive procedure versus the Kasai procedure, which is more or less a stopgap, meaning the child at some point after undergoing that procedure would require what was ultimately done here, i.e. the liver transplant.
So let's talk a little bit about the mediation. Was it a difficult mediation? Did it take multiple meetings? Did you mediate it in one day and resolve the matter? How did that go?
Okay, so going back to a little bit earlier in our discussion, this mediation, unlike most, was not in person. This mediation, because at this point, it was more or less the height of the pandemic, the COVID pandemic. We did it by video. For those listeners, mediation is non-binding. So what is mediation? Mediation is the agreement amongst the plaintiff's attorney, his clients, the defense attorney, and my clients to go to a neutral individual. These neutral individuals, for the most part, are retired judges, retired lawyers, people who have heard or have been involved in many, many lawsuits. Most of them are retired from either being a judge or being a lawyer. The mediation is the opportunity for both parties, the plaintiff's attorney and the defense attorney, to put forth their positions, to lay out what they believe supports their case or what hurts their case. My position always is, before a mediator, is to be fully transparent, provide the mediator with the medical research, and go so far as to provide that mediator with what my experts, should this matter proceed to trial, are willing to testify to. The mediator, in this case, spent a considerable amount of time. Before you even go to mediation, the attorneys provide what's called a mediation statement. You lay down the medical history. You lay down or provide the mediator with research. You want that mediator to understand exactly what occurred here. And again, at least in my opinion, you try to provide the mediator with as much information and be fully transparent. None of this, whatever you say at mediation, is not going to be something that's going to come to haunt you at the time of trial, should the case not settle. In this case, this was my first mediation where we were not in person. It was by video and with breakout rooms, meaning the mediator would speak to both of us. Then the mediator would speak with plaintiff's attorney. Then the mediator would speak with me. Then the mediator would speak with the family of the patient. The mediator then spoke with my clients who were present for the mediation because they have a vested interest in this as well. And ultimately, during the mediation, When questioned about this case, I specifically stated to the mediator with the plaintiff's attorney on the video and said, my experts are prepared to testify that because of my client's departure in failing to diagnose the elevated bilirubin, that the child actually is in a much better position than had he diagnosed the condition earlier in time. Tammie, when I tell you I thought the plaintiff's attorney was going to reach through the computer and grab me by the head, I am not joking.
You're lucky that it was virtual.
In this situation, I was. But when I explained that my two experts were prepared to testify, that, as unfortunate as it sounds, but the patient, or in this case, the infant plaintiff, was able to jump the list because of the liver failure that he was experiencing, he essentially prevented what's called a stopgap treatment, the Kasai procedure, from happening. So instead of having two procedures, he only required one, and the liver transplant as a whole was the definitive treatment for this, not a stopgap, not putting the family in a situation where 5 or 6 years after the initial Kasai procedure that they now had to wait and hope for a proper match for purposes of getting what occurred here, i.e. the liver transplant.
Okay, so that makes sense. So the case ultimately was resolved, right, during that conference. And what, I know we're not going to talk about specific numbers, but just give us like a range of what the case settled for, or how the case was actually ultimately negotiated. What was the end result on that?
Okay, so during mediation, of course, both parties put forth their specific positions. In this case, we had a very good mediator. She was very patient. She had mediated thousands of cases before in the medical malpractice arena, so to say. And we made initially an offer to settle this case that was promptly rejected. After back and forth over the course of many hours, ultimately the case did resolve. Both of my clients were happy with the result. We were able to effectuate a settlement well within each of their policy limits, meaning how much coverage they had. And all of this occurred before depositions of the doctors took place. And on the side, I am going to say to you, the reason why this mediation even took place before that was because when I would have meetings with my clients, both of them were contrite. Both of them were extremely upset. And both of them said to me, John, if questioned whether or not I departed from good and accepted medical care in the treatment of this infant plaintiff in failing to order the proper blood work, I would have to answer in the affirmative. As a lawyer, my job is to minimize the exposure or the risk for my clients, in this case, a family practitioner and a pediatrician. I knew from an emotional standpoint, both of these doctors were extremely contrite. I know that this case kept them up at night. I know that they were emotionally drained by this case, despite the fact that it started and ended relatively quickly. But the last thing I wanted either one of them to have to face was sitting in a conference room discussing their treatment and admitting to fault to third parties. Why is that? Because putting aside dollars and cents and being in the legal arena, you also have to understand that people's feelings are at stake. You have a beautiful family who's obviously gone through a lot, but I also have two clients who are physicians who they're human. Mistakes happen. we drop the ball a lot every day in our lives. But in this situation, dropping the ball, and as much as I tried to tell my clients, yes, you dropped the ball. But guess what? The child actually was lucky that you dropped the ball because they were able to obtain the most definitive treatment extremely timely. I know it's a difficult concept to understand, but for most of us in our field, this is not your normal outcome, meaning it's very rare that you can say that someone's departure from good and accepted medical care actually benefited the patient. In this case, that was our exact argument. That because they failed to diagnose the elevated bilirubin in a timely manner, the Kasai procedure could not be performed, but yet the infant received definitive treatment in the form of a liver transplant.
Right. And he also didn't have to have 2 surgeries and 2 sets of anesthesia, which is never a good thing, especially for an infant or a young child. So they saved him that as well.
And that's it. But, again, at the end of the day, physicians, nurses, PAs, those in the medical field, they're human. And, my clients were, when I say the word contrite, they were beyond contrite. They were beyond upset. I mean, you don't become a pediatrician to harm an infant. You don't become a family practitioner to harm an infant or to tell a mom and dad that they failed. And that was the reason why, after speaking with the insurance company, after speaking with my clients, the decision was made. Let's see if we can mediate this case and resolve it sooner rather than later. And that's the position we took. That's the direction we went. And in my opinion, I think my clients would be the first 2 to also agree, it resolved to everyone's satisfaction.
Yeah. And sometimes it's, in everybody's best interest to resolve these cases early. If there is that clear deviation from the standard of care and no expert support. And as you said, a very sympathetic family, right? So all those things put together lend itself to early resolution. Now, I'm thinking our listeners may be wondering, this was an infant plaintiff who received a somewhat large settlement. How is that settlement structured? Did the parents get the money? Does the infant get the money? How is it ultimately, and how did it ultimately end?
Because you're dealing with an infant, and an infant, for your listeners, is anyone up until the age of 18, okay? They are not an adult. The court system, and I would say the majority of the states follow this rule. While the mother is bringing the cause of action on behalf of her infant son, who is also a plaintiff in this case, when there is a settlement, such as the one we had here, the court oversees the final settlement, meaning while we reached a number that was agreeable to the plaintiff as well as my clients at mediation, thereafter, we then appear before a judge who is handling the underlying civil litigation. And what is provided to this judge? Well, the plaintiff's attorney will provide what's called a compromise order, basically asking permission to the judge to resolve this case based on the terms that we agreed upon. The judge, understanding that this is an infant involved who cannot handle the assets or the money that will be received, 9 times out of 10 will demand that the infant plaintiff's money, meaning the settlement funds, be placed in what's called a structure, meaning a third-party financial company will come in and they will collect the settlement proceeds. and on a monthly basis provide a distribution to the infant, also provide a distribution to the parents, more so to the infant. The purpose of this is that the lump sum should not go to the parents, nor should it go to an infant who can't control the assets or the lump sum. It's a mechanism to make sure that this lump sum payment is spread out over time. I've seen what's called a structured settlement, where a certain amount on a monthly basis is sent to the infant plaintiff, and it's usually held in trust. But when the infant hits 18, 19, 20, additional amounts are provided for purposes of college tuition. But this structure is utilized to make sure and prevent bad people from taking that money, whether it be the family, parents, the cousin who claims he's a financial advisor. So any access to this money while the infant is just that, an infant and not an adult, usually requires court permission. It's actually a very good method to make sure that this money is preserved for the person who deserves it, not the parents, not the siblings, or not the cousin who's a financial planner who came out of the woodwork upon hearing that there was a settlement made. The judge will hold on to the matter, and should the parents require additional funds for maybe adaptive resources or special housing for the infant, which would not occur in this situation, but would occur for those infants who have neurological injuries, the judge is the ultimate decider as to whether or not construction for a home to make it adaptive is required. Things along that nature. Obviously, this came about over many years because in the old days, money would just be dispersed to the family with the hope that the family would have the best interests of the infant at stake. Well, unfortunately, money is the root of all evil, right, Tammie? And sometimes, and it's happened many, many times, where the infant becomes 18 years of age and learns that the money was squandered. Well, this is a stopgap. This is a method to hopefully prevent that from happening. Yeah. And in this situation, a structure was created, a structure settlement, where the infant plaintiff will receive on a monthly basis a certain amount of money that will be held in trust. And when the infant gets to the age of majority or decides to go and hopefully goes to college, there will be lump sum payments made. So that way there is no loans that are required for purposes of tuition or room and board. And it was all set up by us, along with the plaintiff's attorney, who at this point get together for purposes of making sure that the I's are dotted, T's are crossed, and that the final paperwork is all resolved. And hopefully that this infant, along with his family, can go through life knowing that from a financial standpoint, they are secure, specifically he, the infant. Mm-hmm. And as far as my clients, they're just happy that the matter has been resolved. They didn't have to sit for a deposition. It didn't have to go to trial. And sometimes you as a defense attorney have to make that call. And in this case, it was a call that was required. And I'm happy to be part of that call. I have to say, my clients were extremely relieved and felt better knowing that this case was resolved really early on. It's one of those cases where, I'll always remember, based on the timing. Here in this case, it happened to be right as COVID began. Right. But at the end of the day, I cannot remember a case in 26, 27 years of practice where we got it resolved as quickly as we did without making people have unnecessary sleepless nights.
Yeah, that's great. I mean, our physicians don't want to have all that stress if they don't need to go through it. So it was a good result all around. And I believe you said at some point earlier that the child is fine so far, right? He hasn't had any issues from the liver transplant. He's living a normal, productive life. He would maybe be almost 7 or turning 7 soon, I think.
Yes, turning
Yeah.
7.
Mm-hmm.
This March, he will be 7 years of age. My understanding is the child's doing very well.
Good. That's good.
Yeah.
Well, thanks, John, for sharing the story with us. It's, a good lesson learned about, maybe paying a little bit more attention when mothers bring up certain, things that they may see in their baby and just not discount that as like, a new mother or a nervous mother, actually maybe taking their concerns seriously, in the future. I guess that would be the lesson learned maybe on this case.
Never argue with mother's intuition. I guess that would be the lesson of this one.
Right. All right. Well, thank you again for being a guest on The Verdict. And I know we're going to have you back on. So we will not say goodbye. We'll just say see you again soon.
Take care, everyone. Thank you.
And that's The Verdict on our discussion with John Erman. Stay connected with us. Follow Milnick on Facebook, LinkedIn, Instagram, and X for information on our upcoming podcasts. This podcast is for general purposes only and should not be construed as medical, dental, or legal advice. This podcast is not comprehensive and does not cover all possible factual circumstances. Because the facts applicable to your situation may vary, or the laws applicable in your jurisdiction may differ, please contact your attorney or other professional advisors for any questions related to legal, medical, dental, or professional obligations, the applicable state or federal laws, and other professional questions.